Hello and a warm welcome to Well This Week by latestlaws.com. This is a weekly program, so hit the bell icon to get notification for new videos. My name is Sheetal June, Associate Editor, latestlaws.com, and I will be taking you through the significant orders and judgments passed by various courts in the country and some important international news from this week. Let's begin with Supreme Court this week. Stressing on institutionalizing the system of appointment of judges by laying down objective parameters, CJI D Y Chandrachud has said that the SC Collegium has collected data of the top 50 judges in the country who would be considered for the future appointments in the Supreme Court. Justice Chandrachud acknowledged that one of the chief criticisms of the Collegium pertains to the lack of factual data before it to evaluate candidates being considered for appointment. CJI D Y Chandrachud has announced that the Supreme Court will now become under the National Judicial Data Grid platform, which provides tracking of pendency of cases. Making the announcement, CJI said that the initiative will bring transparency and accountability. The Chief Justice of India shared some key statistics showing that there are currently 80,000 cases pending in the top court, with an additional 15,000 cases not yet registered and thus not considered pending. In a significant ruling, the Supreme Court of India has reiterated that when a law is declared unconstitutional on the grounds of infringing fundamental rights guaranteed under Part 3 of the Constitution, it is rendered void ab initio with no legal standing from the date of its enactment. This crucial ruling was delivered by a constitution bench composed of Justice Sanjay Kishan Kaul, Justice Sanjeev Khanna, Justice Abhay S. Oka, Justice Vikram Nath and Justice J.K. Maheshwari. The Supreme Court has directed the Ministry of Home Affairs to prepare a comprehensive manual on media briefing by police personnel about criminal cases. Observing that the biased reporting gives rise to public suspicion that the person has committed an offence, a bench headed by CJI D Y Chandrachud said media reports can also violate the privacy of a victim. The Supreme Court also directed DGPs of all states to submit suggestions in 1 month to the MHA on preparing manual for media briefing by police in criminal cases. The Supreme Court has referred to a 5-judge bench the issue of constitutional validity of the contentious and misused sedition offence under Section 124A of the Indian Penal Code after rejecting the Union government's petition to pause the judicial scrutiny and await Parliament's view on the proposed new code in the Bharatiya Nyaya Sanhita (BNS), which seeks to do away with the provision. A bench of CJI D Y Chandrachud and Justice J.B. Pardiwala and Justice Manoj Mishra backed their decision not to accord to the request by Attorney General R. Venkata Ramani and Solicitor General Tushar Mehta for deferment of the judicial scrutiny of sedition provisions, citing 3 reasons. Now let's have an overview of High Courts. The Delhi High Court has rejected the Trademark Infringement Suit by Ivy League school Princeton University against a group of Indian educational institutions using Princeton in their name. The single-judge bench of Justice C. Hari Shankar has dismissed the petition filed against Hyderabad-based Vagdevi Educational Society, observing that reference made in India do not indicate the US-based institution. The division judge bench of Justice Navneet Kumar Pandey and Justice Chandradhari Sharan Singh of the Patna High Court in the case of Komod Mandal versus the state of Bihar has held that as per provisions of Section 34(2) of the POCSO Act 2012, it is imperative of the trial court to determine the age of the victim. The Bombay High Court has highlighted the importance of a thorough understanding and application of the law, especially in cases involving vulnerable individuals like children. The single-judge bench of Justice Bharti Dangre also underscored the need of accountability in the legal system and when errors made in sentencing. The judge's commitment to upholding the law and protecting the rights of the accused while ensuring justice for the victim. The Jharkhand High Court has allowed a petition seeking an investigation into a murder case of 6 family members and held that where the Constitutional Court is satisfied that the investigation has not been conducted in a proper and objective manner, a fresh investigation with the help of an independent agency can be considered to secure the ends of justice. An entire investigation and the closure report lack bona fides and de novo investigation was required in the present case. The Jharkhand High Court has dismissed a petition seeking employment under the scheme of rehabilitation and held that public employment is not a largesse and Articles 14 and 16 of the Constitution have to be strictly followed in filling a post under government, and public employment cannot be distributed on the mere wish of the person without there being any backing of the law, and no appointment can be granted to any person or victim of a crime in absence of any law. The Punjab and Haryana High Court has reiterated that a convict has no inherent right to claim premature release, as life imprisonment means the whole life of the convict in jail. A single judge bench of Justice Jasjeet Singh Bedi in this view rejected a writ petition filed by a life convict against Haryana government's decision to defer consideration of his premature release for 2 years. The single judge bench of Justice Sunil Dutt Mishra of the Patna High Court in the case of Shri Giridhar Gopal versus Srimati Ramavati Devi held that court can add anyone as a plaintiff or defendant if it finds that he is necessary party or proper party for adjudicating upon the issue involved in the suit. Merely because the plaintiff does not choose to implead, a person is not sufficient for rejection of an application for being impleaded. Moving on to international news this week. Google has exploited its dominance of the internet search market to lock out competitors and smother innovation, the Department of Justice charged on Tuesday at the opening of the biggest US antitrust trial in a quarter century. This case is about the future of the internet and whether Google's search engine will ever face meaningful competition, said Kenneth Denzer, the Justice Department's lead litigator. Over the next 10 weeks, federal lawyers and state attorney generals will try to prove Google rigged the market in its favor by locking its search engine in as the default choice in a plethora of places and devices. US District Judge Amit Mehta likely won't issue a ruling until early next year. If he decides Google broke the law, another trial will decide what steps should be taken to rein the Mountain View, California-based company. A federal judge on Wednesday ruled that a new version of the federal policy that protects hundreds of thousands of immigrants who come to the US as children from deportation is illegal. US District Judge Andrew Hennen sided with Texas and 8 other states that sued to end the Deferred Action for Childhood Arrivals or DACA program. The judge's decision is expected to be challenged in the US Supreme Court, where the program's fate has been decided twice before. In the end, we have miscellaneous news. Asaram Bapu has moved the High Court of Rajasthan for parole after his plea for relief was rejected a second time, his counsel said on Saturday. Allowing his application, the High Court on Friday issued a notice to the state government seeking a reply in 2 weeks. The Union Cabinet, chaired by Prime Minister Narendra Modi, has approved the e-Courts project Phase 3 as a central sector scheme spanning over 4 years with financial outlay of Rs 7,210 crore. In the line with the vision of Prime Minister Shri Narendra Modi's Sabka Saath Sabka Vikas and Sabka Vishwas e-Courts Mission Mode project is a prime mover for improving access to justice using technology. As part of the National E-Government Plan, the e-Courts project is under implementation since 2007 for ICT enablement of the Indian judiciary, the phase 2 of which was concluded in 2023. Phase 3 of the e-Courts project in India is rooted in the philosophy of access and inclusion. Thank you for watching and have a nice day. This is a weekly program, and to get more information, please check the description box, and for weekly updates, like and subscribe to our channel.